Hi everyone. For week two's discussion board, I chose to research and discuss the case Cedar Rapids Community School District versus Garret F. A little bit of background about the case. The respondent was Garret F., a quadriplegic student at Cedar Rapids Community School who required a wheelchair, was dependent upon a ventilator, and required catheterization. The petitioners were Cedar Rapids Community School District, which was already providing a one-on-one educational aide who assisted with raising Garret's hand in class, as well as physically completing his assignments from his input. Garret's parents requested that the school assume financial responsibility for an additional full-time staff to monitor Garret for respiratory distress, provide catheterization, and suction his tracheotomy. Cedar Rapids Community School District argued that this fell under the medical services exclusion and related services and refused financial responsibility. The questions or issues in this case, there are two. What services fall under the related services exclusion for medical services? And does IDEA require schools to have to pay for one-on-one nursing assistance for students with disabilities? I would also elaborate on that question by saying, does refusing to pay for a service that keeps a child in school, does that violate that student's free and appropriate public education? The findings in the case, the Supreme Court determined that continuous services did not automatically constitute a medical service. The school district was basically saying that having to have someone in the building full time, checking on his respiratory and repositioning him in the chair, doing his catheter, suctioning his tracheotomy, all of those things combined made it so that it was no longer something that the school nurse would be able to provide, and that it became something they wanted to consider a medical service. The county proposed a multi-factor test, and essentially the Supreme Court, through questioning, narrowed it down that they were primarily basing this multi-factor test upon the cost and the continuousness of the service. And so the Supreme Court pretty much decided that this multi-factor test was not necessary. They felt that if the procedures individually could be performed by a trained layperson, that the continuousness of the service did not matter, and that if a procedure can be performed by that trained layperson, it's not considered a medical service, and therefore it does not fall under the medical service exclusion that you can find under related services. In this case, they applied the same physician-based test that they used in the Tetro case earlier to determine whether Garret's services were supportive in nature. And really what they mean by supportive in nature was, were those services necessary for Garret to be able to attend school? If it was necessary, then it must be provided. To give a little background into the Tetro case, it was a very similar situation with a young girl who needed catheterization during the day, and they determined that catheterization could be performed by a trained layperson and was therefore not a medical service. While Garret's case is unique and a little bit different from that one in that he had multiple medical concerns that needed addressing throughout the day, pretty much on a continuous basis. The school district was required to pay for the additional aid to provide support for his respiratory, tracheotomy, and catheterization needs. And Garret's medical condition was found to be related to keeping him in school and providing him a free and appropriate public education. The outcome of the case, in a 7-2 decision, the Supreme Court ruled in favor of the respondent, in favor of Garret F. and his family, stating, yes, if a service is related to keeping a child with disabilities in school and able to benefit from special education, and that benefit from special education goes back to what free and appropriate public education comes from, the very definition of what we're trying to do is to have a child benefit from special education. If this service, his continuous nursing care, did need to be there in order for him to benefit from special education services, then it was necessary. The type of service, the continuousness of the service, the cost does not determine if the school district must cover the financial costs. So the implications for students with disabilities. Like I said before, this court case further expanded upon the Tetro case, which set the precedence that intermittent catheterization and other similar services like the one Garret required do not fall under medical exclusion. This case further reinforced the meaning behind free and appropriate public education. The cost or difficulty in practice cannot be a sole determiner in a school district's decision to approve or reject a service. My personal position on this case, I have mixed feelings about this case's outcome. I can definitely see working in a school district that the cost and the inconvenience and just the amount of scheduling and planning that would go into having this additional staff sitting with Garret all day in order to monitor his respiration could possibly be handled by the educational aide who was already present. So a lot of what they were asking for in Garret's case was to check to make sure he was not in respiratory duress. Whether an additional person needed to be there to see and watch him and see is he in distress? My question was, could that be provided by the educational aide? And when I was listening to the recording of the case in court at the Supreme Court, that question was brought up, but it wasn't fully expanded upon. Another thought that I had while researching this case, and it was not discussed, again, I listened to the entirety of the case presented in the Supreme Court. They never mentioned that the respondent, Garret's family's argument that the catheterization and suctioning of the tracheotomy was intermittent and that it was only required once in the case of catheterization and twice in the case of the suctioning of the tracheotomy. My question then is a service that needs provided once or twice a day. My question was whether these services could have been provided once before and once after school by a privately hired nurse or by his parents. And sort of the question of how many times within an 8-hour period was this really required? Could Garret have gone to school and gone through that 8 hours had he been catheterized in the morning and this tracheotomy suction before he went to school? Could he have made it through that 8-hour period without having to have those things done again? I know that's a question that I'm sure a medical person would have to answer, not me, but I guess if that's possible that those things could be done at home, why weren't they being done at home? Why did Garret's family feel like that needed to be done at school? How the findings will impact my teaching and learning. So this case specifically will affect me and my role as case manager. I have not yet had to write an IEP for a student with this type of related service or really any significant health impairment. However, I imagine that at some point in my career, this situation could arise, and I could be placed in a situation where parents are requesting services, and my county questions or even disagrees with the service being covered under IDEA, and more specifically, as a related service, could it be found as a medical exclusion? Actually, while I was researching this case, I spoke to my special ed director at my school, and there was a case very similar to this, and it's actually still being processed through in my division. It's not particularly at my school or in my caseload, but from what I heard about the case is that they were providing a full-time aide to provide these medical services, despite them being pretty clearly a medical professional was required. I won't get into any of the specifics, but it was definitely seemed like a medical professional would be needed to provide these services. However, it was written into the language of the IEP by a previous case manager that those services would be provided by the school, and as such, that it continues to stand in that way. The parent refuses to remove those services. The school is kind of stuck in an impasse with having to provide them. And it was actually very interesting that I heard about this while learning about this case. So it does happen, and there are situations where this case might be relevant to me in my career. I included my citations. Actually, the first citation I really recommend you guys look into if you're looking up cases. It has full transcripts and audio of Supreme Court cases, and you can look them up just by the name. You can listen, you can read the opinion, you can read the counter opinion. Just a really great source. The second source is obviously our special ed book that we were given, The Law in Special Education by Mitchell Yell. And the final source was actually my article that I found that supported my opinion on the case. It did sort of turn the question to, all right, the court has ruled that these services need to be provided and they are not medical exclusions. And it was turning it over to Congress saying, now it's your turn. Now it's your turn to sort of say, if you receive federal funding through IDEA, you must provide these services, to sort of expand upon the ideas in IDEA and say, this has been determined that this is not a medical exclusion. We cannot keep trying to do this and trying to get away with saying it's a medical exclusion. Congress needs to up the ante and say, school divisions, if you're accepting our money, this is kind of what you have to do. So I actually really liked that article. It gave a lot of background information too about Tetro, about this case in specific, and also Rowley. So it's just a really good read. Thank you so much for watching my video, and I look forward to responding to some of yours, and I hope you have a great rest of your week. Thank you.